Hi, good afternoon, everyone. Thank you so much for joining us today. We are going to give it just another minute to let people join, and then we'll get started for our webinar. Thank you so much for being here, and feel free to introduce yourselves in the chat in the meantime. All right, I want to be respectful of everyone's time, so we're going to get started today. Good afternoon, everyone. Thank you so much for joining us today for What to Expect in New York Family Court, a beginner's guide. We're thrilled that so many of you could join us today. It's nice to see so many familiar faces in the chat. Continue to introduce yourselves, please. This webinar is intended to provide an overview of family court and family law in New York State. We want to take a moment to acknowledge that October is Domestic Violence Awareness Month, and we know that many organizations and experts will be discussing the many topics that are related to domestic violence, such as safety planning and orders of protection. And we also want to recognize that we want to recognize the many family court topics that come up in family court that can be related to domestic violence and wanted to provide a general overview of family law and family court for folks today. But that said, this webinar is for anyone who is looking to know more about family law and family court as well as family legal care services. So if you are someone who is going through family court issues right now and you're seeking guidance and information, welcome. We're so glad that you're here. If you're a service provider or an advocate, or if you're just interested in learning about family law, we're really glad that you're here as well. So before we get started, we'll do some quick introductions. My name is Molly Burke. I am the Associate Director of Advocacy, Policy, and Community Engagement at Family Legal Care. I am also one of our staff attorneys. Ebony?
Hi, good afternoon, everyone. I'm Ebony Morell. I'm the Community Engagement Manager here at Family Legal Care. Thank you all so much for spending the afternoon with us. Sandy?
Hi, my name is Sandy, and I'm a program associate in the Queens Family Court, and I'll be taking care of the chat today.
Thanks so much. And a couple of housekeeping items before we get started. We really want this webinar to be interactive, so here are some ideas of how you can participate. If you haven't already done so, please say hello and introduce yourself in the chat. I see it is robust, so please keep doing that. And throughout the presentation, we'll be asking a series of poll questions. Please participate. We'd love to hear from you, and it's a great way to also test your knowledge. We'll save time for questions and answers at the end of the session, but as we're going through the presentation, please submit any questions you have to the Q&A button at the bottom so that we are sure that we won't miss any of your questions that come in. And then finally, feel free to send us a chat if you have any comments or concerns that come up during the webinar. So now to our first poll. What brings you here today? A, I am a parent or caregiver. B, I am a partner or advocate looking to help my clients. C, I am interested in learning about family law, or D, something else. We'll give you all just a moment to pick what best suits why you're here today. Okay, and if we could have the results, please. Awesome. Looks like we've got a good mix of people here today. So now a brief overview of what we're going to cover today. Ebony is going to start us off with an overview of family legal care services, including how to reach us if you or your clients need support, before giving a brief introduction into family court and an overview. Ebony and I will then dive into our substantive law portion and start us off with an overview of paternity and parentage, or the process of becoming a legal parent, before discussing child support, how to file and respond to an initial child support case, and how to address some arrears or unpaid child support. I'll then give an overview of custody, visitation, and guardianship in family court, discussing the different types and how a jurist, or someone who decides a case, makes a decision in each of these different types of cases. And finally, Ebony will go over orders of protection and share some resources and referrals before we save time at the end for some Q&A. As we're discussing these topics, I just want to note that all of the material covered today is intended to be legal information only and not advice. As I mentioned earlier, we encourage you to submit your questions using the Q&A feature below, but you may hear us tell you to contact our helpline or to speak with an attorney for more specific legal advice. And that's because every situation is different, and what applies to one person may not apply to everyone. So with that being said, I will turn it over to Ebony to kick us off.
Thank you so much, Molly. So before we get to the presentation, just a quick reminder that Family Legal Care changed its name. You may have known us previously as Legal Information for Families Today, or LIFT, but we are now Family Legal Care. All of our programs and services, which we will go over in just a moment, have remained the same, but we're really excited because we think that our new name, Family Legal Care, better represents who we are, what we do, and the heart of our mission, which is to provide compassionate support and care for families going through the New York State Family Court, and ultimately to help increase access to justice. Next slide. On that note, let's go ahead and get started. So first, here's an overview of who we are and what we do. If you're not familiar with Family Legal Care, our story goes back all the way to 1996, when a group of 3 young lawyers fresh out of law school realized that there was a real need in the New York family court system for people to get basic legal information. With permission from the supervising judge in the Manhattan Family Court, they set up a folding table there in the court and stationed themselves there to answer questions and offer guidance to anyone who needed some help. Over 25 years later, our organization has really grown, yet our mission effectively remains the same. And again, that's to increase access to justice for families in New York Family Court. Today, we do this by offering parents and caregivers free legal information and advice, as well as easy to access resources and technology to help them navigate the family court system here in New York, not just in New York City, but all over New York State. The first program we'll go over is our bilingual helpline. Our helpline gives information about New York family law and family court procedure by phone, live chat, and email. Our helpline is also an entryway to our other services. So if someone is interested in meeting with an attorney, which I'll discuss in just a moment, our helpline associates will conduct a screening to see if the person is eligible for a consultation. And if they are, they'll go ahead and schedule that appointment. I will say, though, that oftentimes people find that after speaking with our helpline, they get all of the information that they need to figure out their next steps. Our helpline associates are truly amazing and can give people a wealth of information or point them in the right direction. Our general helpline hours are Monday through Friday from 9 a.m. to 5 p.m., although we do close for lunch from 1 to 2 p.m. every day. The phone number for the helpline is listed here on the slide, and that's 212-343-1122. And you can also access our helpline on our website for the email and live chat options. And Sandy went ahead and plugged that information into the chat as well. So at Family Legal Care, we offer limited scope representation. What this means is that we have a team of staff and pro bono attorneys who meet with unrepresented parents and caregivers for 1 hour consultations, either by phone or video chat. The level of support the attorneys provide during these consultations really depends on the case and the litigant's needs. But some examples of what our attorneys can do include providing legal guidance on next steps, helping litigants prepare and file petitions or motions with the court, and advising litigants on how to effectively represent themselves in court. Also, depending on the case and the litigant's needs, our attorneys may be able to provide follow-up consultations and follow-up support as necessary. If you or someone you know is interested in a consultation, you can visit our website to learn more or reach out to our helpline. It's important to note that we don't have any income or residency requirements for any of our services. For a consultation, the only requirements are that the litigant is not already represented by an attorney, that the case is one of the types of cases listed here on the slide, and that the case is in the New York Family Court. We provide consultations on paternity and parentage cases, child support, custody, visitation, and some guardianship cases. We can also advise people regarding domestic violence issues and orders of protection as they relate to the issues listed here on the slide. However, we cannot offer a consultation for a standalone order of protection case. We do not provide advice on divorce cases, since in New York State, those are handled in the Supreme Court, not family court, and we also do not provide advice on abuse and neglect proceedings. We also offer over 60 original legal resource guides, which provide step-by-step information on a range of New York family law topics, such as service of process, custody and visitation basics, child support basics, ABCs of family court, and so much more. The guides are available in 9 different languages on our website, and they're also available in the family courts in all 5 boroughs of New York City. In the family courts, we also have some of our legal resource guides available in Braille and large print. Next slide. We also have legal information and tech hubs in the family courts in the Bronx, Brooklyn, and Queens. Our legal information and tech hubs are kind of like our helpline, but in person. So we have trained program associates who provide information on family law and court procedure, as well as targeted community referrals and access to other family legal care services, such as our attorney consultations. Our program associates can also provide access to and assistance with technology as it relates to your family court needs. We can provide access to computers, a private space to attend a virtual court date, assistance downloading or printing forms for the court, and more. The hours and locations for our legal information and tech hubs are listed here on the slide. Next slide. We also have our Digital Justice Initiative, which is made up of 3 main tools: the Family Law Navigator, our guided court forms, and our Family Law Explained videos. All of these tools were designed to be accessible using any device, whether that's a computer, a smartphone, or a tablet. Through our Family Law Navigator, users can answer 3 to 12 simple questions about their situation, and at the end, they'll receive a personalized report with information and next steps that they can take. The Navigator is similar to our legal resource guides in content. However, it is personalized based on each person's responses to the questions. Our guided court forms are just that. So we recognize that family court forms and petitions can be very complex and difficult to complete on your own. So this program breaks down popular family court forms and petitions into simple questions. And at the end, users will receive a completed document either in PDF or Word format that they may download and submit to the court. And lastly, we recognize that everyone has a different learning style, so we created 2 to 3 minute long animated videos about different family court topics, such as serving court papers or filing for custody. The videos are all available in English and Spanish, and all of these tools can be accessed on our website. So that's just a quick overview of family legal care and the programs and services that we provide. Just to reiterate, all of our services and programs are completely free, regardless of your income. If you have any questions, please feel free to ask during our Q&A session later on, or please visit familylegalcare.org to learn more. Now, before we get into the law portion of the presentation, I want to lay some groundwork and give a really brief overview of the family court system here in New York. The New York Family Court hears and decides certain types of cases, such as the ones that you see listed here on the slide. The ones that are listed in green are the types of cases that family legal care attorneys can advise on. That includes paternity and parentage, custody and visitation, child support, domestic violence, and some guardianship cases. Remember that in New York, divorce is handled in the Supreme Court, not the Family Court. And another note that you should know before we move on is that every county in New York has its own family court, including one per borough in New York City. The New York Family Court is intended to be a pro se court, and pro se just means unrepresented by an attorney. This means that the family court is intended to be more friendly and more accessible for those who do not have an attorney representing them. For example, there are no filing fees in family court, and the rules are supposed to be more friendly and more simple. As a matter of fact, 80% of litigants are not represented by an attorney in the New York Family Court. There are certain types of cases in family court where a litigant may be able to get a lawyer assigned to them at no cost, but this will really depend on the type of case and on your income. We'll go over this a little bit more later on in the presentation. A petition is the form that you use to start a case in family court. You may file an initial petition, a modification petition, or an enforcement petition, sometimes also referred to as a violation petition. An initial petition is used to start a case, for example, to ask for child support or to ask for custody of a child. If you file a petition, you are known as the petitioner, and the person that you are filing against is known as the respondent. A modification petition is used to ask for a change in an existing court order, for example, asking for a different visitation schedule or a change in child support. Lastly, an enforcement or violation petition is used to let the court know that the other party is not following the order. For example, if they are not returning the child after visits or if they're missing child support payments. Generally speaking, you can only file a modification or violation petition on a final order, not on a temporary order. And you usually have a final order if there are no more court hearings for that case. Also, please note that you do not need a lawyer to file a petition in family court. You have the right to file and start a case on your own. Next slide. Before we wrap up this section, a quick reminder that if you file to start a case, it is your responsibility as the petitioner to serve or notify the other party, which again is the respondent. Now I'm going to turn it back over to Molly for an overview of paternity and parentage.
Thank you so much, Ebony. All right, so let's talk about paternity and parentage and what that is. A few years ago in New York State, the law shifted from paternity, the legal status of being a father and becoming a legal father, to parentage, the legal status of being or becoming a parent. Parentage is broader. It recognizes more people as legal parents. And what this means is that same-sex couples, single parents, and parents who use assisted reproduction can more easily become legal parents of a child in New York State now. A lot of people still use the term paternity, but for this presentation, I'm going to generally use the term parentage. You'll often hear from the court or lawyers about establishing parentage or paternity. This really just means determining or proving who the legal father or parents of the child are. And why does this matter? Well, parentage must be established legally before any custody, visitation, or child support case can be heard in court. And once parentage is established legally, parents have equal rights and responsibilities over their child. So now, who can file for paternity or parentage in family court? Only the mother, father, or child can file for paternity or parentage in family court. Is that true or is that false? A for true, B for false. Only the mother, father, or child can file for paternity or parentage in family court. Okay, and if we can have the results, please. False. Good. Some of you may have come to our previous webinars. Many different people other than just mom, dad, or the child can file to establish parentage in family court. Notably, the Department of Social Services, if a child is receiving public assistance benefits, DSS, the Department of Social Services, will file to establish parentage in family court if it hasn't already been legally established before they file for child support, which Ebony is going to talk more about in just a little bit. Additionally, an intended parent can file, and this is someone who is defined by the law, and it's exactly what it sounds like. This is a person who intends to be a parent of a child, even if they are not biologically related to the child. So, for example, in instances of gestational surrogacy. Why does parentage have to be established anyway? Well, like I mentioned, once parentage has been legally established, both parents have equal rights and responsibilities over their child unless a court order says otherwise. This means that both parents are financially responsible for their child and both can make legal decisions for and about their child. Again, unless a court order says otherwise. You must legally establish parentage before any child support, custody, or visitation case can be heard in family court. So this means that before filing for any of those types of cases, you have to file or you have to establish parentage legally first. Now let's talk about how you can establish parentage, and there are a few different ways. The first way is through marriage and through what's called the presumption of legitimacy. This means that when a child is born to a married couple, those parents are automatically the legal parents of the child. Generally, you don't have to establish parentage in court, although you can still file and establish it in court if you want to. The second way to establish parentage is if the parents are not married, but they sign an acknowledgement of parentage or AOP after the child is born. Whoever signs this legal document will be considered the legal parent of the child. And the AOP is a form that's filled out by both parents stating that the individual filling out the form is the parent of the child. It's a separate document from a child's birth certificate. You do not have to go to court to legally establish parentage with signing this document as well. By filling out and signing it, the AOP, parentage has been legally established. And the third way to establish parentage is through going to court. A court order of parentage or an order of filiation, or sorry, a judgment of parentage or a court order of filiation is a court order that's entered by a support magistrate or a judge after a parentage case is filed. The jurist can issue or enter this order when the parties either consent or agree that the other parent is the legal parent of the child, after evidence has been presented to prove that someone was an intended parent and should therefore be a legal parent, or after a genetic marker or DNA test is ordered by the court. Now, a common question we get is about out-of-court DNA tests. For example, a DNA test from CVS or from Walgreens, and whether that's admissible. It's not. Only a court-ordered DNA test is allowed or admissible in court. And then lastly, equitable estoppel is something that can come up during a court proceeding that can prevent someone from challenging parentage. This can happen when someone has held themselves out or acted as a child's parent. The court may not want to remove someone who has an important role in a child's life, and that could affect the best interests of that child. This can be a really complicated topic, so if you have any questions about equitable estoppel or parentage, please reach out to Family Legal Care at 212-343-1122 or speak with another experienced family law attorney for questions about your individual case. And again, once parentage is legally established, either through marriage and the presumption of legitimacy, through signing the AOP or the acknowledgement of parentage, or through a court order, both parents share equal rights and responsibilities over a child. Again, unless a court order says otherwise. And now I'm going to turn it over to Evany to talk through some child support with you.
Thank you so much, Molly. So now we're heading into our child support section. You can go on to the next slide. So what exactly is child support? Child support is the financial support that the non-custodial parent, which is the parent that does not live with the child the majority of the time, pays to the custodial parent or caregiver, which is the person who lives with the child, or to the Department of Social Services if a child is receiving public assistance. The custodial parent or caregiver can receive child support even if they do not have a court order granting them custody of the child. Child support can generally be broken down into two parts: the basic obligation to cover the basic necessities of the child, such as food, clothing, and shelter, and add-ons for unreimbursed medical expenses, childcare expenses, and certain educational expenses. In New York State, child support generally goes until a child turns 21 years old. However, it can sometimes be extended until a child is 26 if the child has a developmental disability. And generally speaking, there is no right to a court-appointed attorney in child support cases. So this means that you might have to hire an outside attorney or represent yourself in a child support case. The only time that the court may assign an attorney in a child support case is to a non-custodial parent in a violation proceeding if they are facing potential incarceration for not paying their child support. And as a final note, child support and custody and visitation cases are handled separately in family court, so each case will be heard by a different jurist. Child support cases are generally heard by a support magistrate, whereas a custody or visitation case is generally heard by a judge or a referee. Generally speaking, the court will use a formula set forth in the Child Support Standards Act to calculate the amount of child support. The court will try to base this amount on the party's actual income, but they can only do so if the parties actually appear in court, whether that is virtual or in person, and if the parties provide credible evidence about their income. So this includes a financial disclosure affidavit or affirmation, W-2s, tax returns, pay stubs, and any other documentation that the court asks for. Please also note that child support is generally retroactive to the date that the support petition was filed in court or from when the child goes on public assistance in a DSS case. That amount will usually be added as a lump sum to the child support order, which can often be paid off little by little over time. If you're providing financial support to the custodial parent or caregiver from the time that the case started in court, you can lower your arrears by getting a credit. So you want to submit evidence of payments, whether that's through Zelle, money orders, Venmo, etc., to the support magistrate in order to get this credit. As I mentioned earlier on, child support can be broken down into two parts: the basic obligation to cover the basic needs of the child, and add-ons for unreimbursed medical expenses, childcare expenses, and certain educational expenses. Please note that the educational expenses generally do not include college. If college is going to be included in child support through the court, the parties must agree on it beforehand. Here we also have the percentages set forth in the Child Support Standards Act. So for one child, the amount of support would generally be 17% of the combined gross income. For two children, it would be 25%. For three children, 29%, and so on. Next slide. If you're looking to change your final child support order, you can do so by filing a modification petition, which, as I mentioned earlier, a modification petition is what you file to ask the court to change a final order. To request a modification of a child support order, you must prove at least one of the following three things to the court. One, that either party's income has changed by 15% or more, whether that is an increase or a decrease. Two, that more than 3 years have passed since the last court order for child support was issued, or that there has been a substantial change in circumstances. A substantial change in circumstances could be anything like a change in custody. So if the child is living with another adult, an emancipation event, such as the child joining the military, getting married, or in cases where the support order is for two or more children, if the older child turns 21 years old. Incarceration or a change of employment could also be a substantial change in circumstances. It's important to note that losing a job in and of itself does not mean that the court will automatically modify the child support order. First, you must file a modification petition. And in these situations, the court also wants to know the reason that the job was lost. And they also want to see what efforts the person is making to get a new job at the same or similar income. Another important thing to keep in mind is that, again, child support petitions are generally only retroactive to the date that they are filed, which is why it is very important to file a modification petition as soon as there has been a change in circumstances. So let's say, for example, if I lost my job back in January, but I don't go into court to file a modification petition until August, then from January until August, I am responsible for paying the amount of support that was determined in my original order. If the court then grants my modification petition and they change the amount that I have to pay, that change will usually only apply from August forward because that's when I actually came into court to file. And that brings us to our next poll, true or false. Child support arrears go away when a child turns 21. We'll give you all a moment to answer. Okay, let's see. So the majority of you said false, which is correct. Child support arrears do not go away when a child turns 21. So before we get into it, what even are arrears? Arrears are unpaid child support. So if you're not paying your court-ordered child support obligation, then you may owe arrears. It's very difficult to change arrears once they are in place. If you owe arrears directly to the custodial parent or caregiver, they are usually the only person who can forgive or waive the arrears owed to them. If the child is receiving public assistance and you owe arrears to the Department of Social Services, there are certain arrears reduction programs available in New York City that can be used to manage your child support debt. In this case, you should reach out to the Office of Child Support Services to find out more information about these programs and to apply. And we'll provide their contact information in the following slide. Again, because it's so difficult to change arrears once they are in place, it is very, very important to file a modification petition as soon as there has been a change in circumstances or as soon as otherwise applicable. And as promised, here's the contact information for the Office of Child Support Services. They offer different services for both custodial and non-custodial parents, such as help filing for child support, helping to locate and serve the non-custodial parent, collecting support payments, and keeping track of the account, among other services, including those arrears reduction programs I mentioned briefly earlier. And before we wrap up the child support section, we want to leave you all with this. A parent has the right to visitation with their child, even if they are not paying child support. Again, child support and custody and visitation cases are handled separately in family court, so one does not necessarily affect the other. Now I'll turn it back over to Molly for custody, visitation, and guardianship.
Thank you so much, Ebony. Okay. So that is a perfect transition into our next section about custody, visitation, and guardianship. We are going to go over each of these in detail, but this section is going to go over who has the right to make decisions about a child and to care for a child and about where a child lives. Now let's talk briefly about what custody and visitation and guardianship is before we dive into how to establish it, who can file for it, and the different types that there are. So custody is the right to parent your child. Physical custody means where the child lives, and legal custody is the ability to make major decisions impacting your child's life. For example, over education, medical, healthcare, and what religion your child practices. You can file for custody or visitation in the family court where your child has lived for the past 6 or more months. Visitation means the parenting time between a non-custodial parent or the parent that the child does not live with the majority of the time and the child. Parenting time can look very different depending on the child and the parent's relationship. This could be daytime visits, overnight visitations, alternating weekends or weeks. It could be supervised either by a third party, such as an agency or even a grandparent, or it could be unsupervised. They can look like FaceTime visits or phone calls if a parent lives far away, or even if they live down the street. What kind of custody or visitation someone has and how it looks is based on what is in the best interest of the child, which we'll go into more detail on next. Guardianship means having the legal authority to make decisions for another person or even about property. Today, we are only focusing on addressing guardianship of a person, of a minor, in family court. There are many, many, many different types of guardianship, such as guardianship of property or guardianship of an adult, both of which can be heard in Supreme Court. Again, we are going to be talking about guardianship of minors in family court only today. So now let's talk about the best interests of the child legal standard that you've heard us refer to throughout this presentation. But before we do, time for our next poll. Can a child decide who they want to live with? A, yes. B, no. C, maybe. And we included this poll because we get a lot of questions, or we get this question pretty frequently. So can a child decide who they want to live with? A, yes. B, no. Or C, maybe. All right, and if we can have the results, yes, the majority of you put maybe, and that's correct. C, a child may be able to decide who they want to live with, but who they live with will ultimately be based on what is in the best interest of the child. Family court tries to keep children out of court and keep their lives stable and maintaining their lives as best they can when their parents are in family court. So, in order to have a child's voice heard, the court will often appoint a lawyer to represent the child in court and represent what the child wants. So, a child could tell their lawyer who they want to live with, and then their lawyer will represent that desire to the jurist or the person who's overseeing the case. So the court is going to look at a number of factors when they're making a decision about custody, visitation, and guardianship of a child, with what the child wants being one of those factors. Some of the factors include who can provide stability and continuity for the child. They're going to look at who has been the child's primary caretaker. They'll look at the quality of the home environment. Does one parent live in an area that's surrounded by other family and friends? The court's going to want to know the ability of each parent to provide for the child's emotional and intellectual development, the relative fitness of each parent. Are there any mental health or substance abuse issues that the court should know about? The desires of the child and the child's preferences, especially as they mature. If one parent and interference with visitation rights. If one parent can help foster a relationship with the child and the other parent, that will be looked upon favorably by the court. And then any other relevant factor. The only factor that a court must look at and address in a court order, if it's brought up, is domestic violence. But these are all of the different factors that the court is going to want to know when they're making a decision about custody and parenting time or guardianship of a child. And it's known as the best interests of the child legal standard. We talked about who can file for parentage in family court, and it was a number of different people, and we talked about who can file for child support, but who can file for visitation and who can file for custody is different in New York State. Standing means the right to file. So standing for visitation means that you have the right to file for visitation. Only certain groups of people can file for visitation in New York, and that's parents, legal parents. Again, parentage must have been established first, and they always have the right to file for visitation. But the court will determine visitation or parenting time based on what's in the best interest of the child. And grandparents and siblings also have standing to file for visitation, but they have to show equitable circumstances, usually a close relationship with the child, and that they're not being allowed to visit with the child now because of a special situation. For example, one or both parents are deceased or incarcerated. And then they also have to show that visitation would be in the best interest of the child. And then standing to file for custody, the right to file for custody is any legal parent. So again, parentage must be established legally first, or anyone, any non-parent caretaker, but they must show that there are extraordinary circumstances. For example, they've been taking care of a child for a very long time. And again, it's in the child's best interest for them to have custody. It's very hard to take away a parent's right to custody. Generally, the court will not disturb a parent's right to file for custody unless there are those extraordinary circumstances and it's in the child's best interests. So now let's talk about the different types of custody through court. You should know that these types of custody can be mixed with physical and legal, and they're determined based on what is best for each family and what's in the best interest for each child. For example, you could have joint physical custody, but sole legal custody, and we're going to go over three main types today. First, over on the left is sole custody. One parent has all of or the majority of the parenting time where the child lives with them, plus or all of the legal decision making over a child. Full custody is often used interchangeably with sole custody, but sole custody in New York is the proper legal term. Next, in the middle is joint custody. Joint custody, joint physical custody is where both parents share where the child lives, and joint legal custody is where both parents share legal decision making about the child. And then over on the right is zones of decision making or spheres of influence, where parents have authority over different areas of a child's life. For example, one parent may have decision-making authority over medical decisions, while the other parent has authority over educational decisions. And then lastly is shared custody. This is what parents have when there is no court order. Both parents share equal rights and responsibilities over a child when parentage is established until a court says otherwise. Now let's discuss the different types of guardianship. But first, what's the difference between guardianship and custody anyway? Well, in New York State, there are very few differences. However, in other states, there can be many differences between the two. So if you're planning to move or to relocate, you should find out about the laws in the state where you're going, which will help you decide whether you want to file or ask for custody or guardianship. Custody is the legal right and responsibility of a legal parent or caregiver that they have for their child's life and well-being, while guardianship is a court-appointed role where often a non-parent is taking full responsibility for a child, potentially due to the parent's inability to care for the child. So here are some common facts and differences between guardianship and custody in New York State. First, where to file. For custody, you can file in either family court, what we've been going over today, or in Supreme Court as part of a divorce proceeding if the parents were legally married. Guardianship, like I mentioned before, can be filed in family court, in Supreme Court, or in surrogates court, and where you file often depends on the type of guardianship. Is fingerprinting required? Fingerprinting is generally required for the entire household, generally required for the entire household for guardianship, but it's not required to gain custody. How long does it last? Custody lasts until a child turns 18, where guardianship can last until a child is 21 years old. There are many different kinds of guardianship, like I was talking about earlier. And as a reminder, you can file for guardianship in Supreme Court, in Surrogates Court, as well as Family Court. We're going to focus on just 4 different types of guardianship today that take place in Family Court. So the first over on the left is guardianship of the person. Guardianship in family court allows someone who is appointed by the court to make life decisions for a minor child, such as about the health, welfare, and educational decisions. This is something you must go to court for. Next, over here is standby guardianship. This allows parents with terminal illnesses or parents at risk of deportation or removal proceedings to plan for their minor children's care when they are incapacitated or when they can no longer take care of their children. A standby guardian is someone who is given temporary authority to care for another person's minor child. This is something that you must go to court for as well. Next, in purple, is designation of person in parental relationship. You do not have to go to court for this one. This is a short-term solution, so up to 6 months, but you can renew it every 6 months. And parents can designate or appoint someone as a temporary designee of their child. Both legal parents must sign off on this and agree to who this is and sign the paperwork for that. And then lastly, KinGAP, or the Kinship Guardianship Assistance Program, is a resource for children in the foster care system to be placed with a relative guardian. KinGAP is designed for a foster child to achieve permanent placement with a committed adult who had been the child's foster parent for at least 6 months. These can also be confusing, so if you have any questions, please feel free to put your questions in the Q&A box, or please reach out to our helpline at 212-343-1122. Go to our website, familylegalcare.org, or speak with an experienced family law attorney for more information. And please know that a parent can request a court-appointed lawyer when they go to court, but the parent must meet an income eligibility requirement. Parents can bring in evidence of their income to present to the jurist at their hearing, and then the jurist can appoint them a lawyer to represent them in their custody or visitation case. Now I'm going to hand it back over to Ebony to talk through family offenses and orders of protection.
Thank you, Molly. So now we're moving into our final section before Q&A, family offenses and orders of protection. There are a few different ways through which a person can get an order of protection in New York State, and today we're just going to discuss getting an order of protection through the family court versus the criminal court. Next, thank you. The first step to getting an order of protection through the family court is filing a family offense petition. In order to file a family offense petition, you must be related to the person you are filing against by blood or marriage, someone with whom you are in or have been in an intimate relationship with, or someone with whom you have a child in common. Anyone can walk into the family court and file a family offense petition as long as they meet the relationship criteria and a family offense has been committed. On the other hand, though, a person cannot walk into the criminal court and file a petition. And this is because criminal cases are usually brought to court by a prosecutor or an assistant district attorney, usually after the police have conducted an arrest. So to get an order of protection through the criminal court, there must first be an arrest by the police. Another important distinction between criminal court and the family court is that there is no relationship requirement in the criminal court. So the two major differences, there's a relationship requirement in the family court that does not exist in the criminal court, and there is no police involvement necessary in the criminal court, in the family court, but it is necessary in the criminal court. I will add, though, that the police may become involved in an order of protection case in the family court if the respondent, which is the person that the order is against, violates the order of protection. At that point, the police may become involved to enforce the order. That brings us to our final poll of the day. Can a parent see their child if the other parent has an order of protection against them? A, yes. B, no. C, maybe. We'll give you all a moment to answer. Okay. So we got a mix of responses. The answer is maybe. So an order of protection in and of itself does not necessarily mean that the non-custodial parent cannot visit with or see their child. This will really depend on what the order says and whether or not the children are listed on the order of protection. As Molly discussed earlier on, the judge will then decide if visitation is in the best interest of the child. Now for some frequently asked questions about orders of protection. Can I file for an order of protection for my child? Yes, you can ask the family court for an order of protection that protects you, your child, or both. Can my information be kept confidential? Yes, you can fill out an address confidentiality waiver with the court, and if granted, this will allow you to keep your address confidential. Please note that if your address is confidential, you must keep the court updated anytime that you move, because this is how the court will serve or notify you of any further court dates or cases against you. How long do orders of protection last? In family court, a temporary order of protection generally lasts until the next court date. Once that temporary order becomes a final order, it'll usually last for 2 years, but it can be up to 5 years depending on the case. And can I get a free lawyer? Yes, you can get a free lawyer if you are eligible. You can ask the court to assign an attorney to you on the first court date. And before we wrap up, here's a list of resources at the city, state, and national level where you can get help. The New York State Coalition Against Domestic Violence also has a directory of programs by county where you can find out about shelters, counseling, referrals, and other services near you. And Sandy will put that link along with other resources in the chat.
Thank you so much, Ebony. All right. Before we get to our questions, we wanted to take a quick moment to say thank you. We would love to hear from you and get feedback on today's webinar. And as an incentive for completing our feedback form, we will send you copies of the slides from today's presentation. The feedback form is listed here and is going to be linked in the chat. So with that, I know we had some questions come up throughout the presentation, but Sandy, would you like to have some questions for us?
Yeah, so I'm looking at the Q&A, and there's 3, so I'm gonna go
Great.
by one. So one is, are there differences that we should know between family courts in the different boroughs?
There are differences between, it's a good question. Each jurist may, or the person who's overseeing the case may address how they want, let's say, evidence submitted differently, or how, when they want the evidence submitted, but the family law is the same. So everything that we presented on today is the same no matter where you are in New York State. But how things operate may operate slightly differently, if that makes sense.
Okay, the second is, what is the difference between legal custody over a minor and guardianship over a minor?
It's a good question. So, like I mentioned, there's really few differences about custody and guardianship in New York State. It depends on the type of guardianship that you're looking for, but guardianship in family court is who can file for it. It's really about how you get there and how you're filing for it. So in New York State, there's really few differences. It's a court order that allows you to make decisions over a minor, and to care for a minor child, but how you get there and how you file for guardianship versus custody can be different.
Okay. Let's see. I'm not sure what this means, but do you have a legal, oh wait, yeah. Do you have a legal equivalent on Long Island? I'm guessing they're asking if there's similar organizations as us in Long Island.
I'm not sure, but we do serve Long Island as well. Ebony, do you want to take this one?
Yeah, of course. So we operate statewide, so we can assist anyone that has a case in the New York Family Court, even if, for example, they're living in Florida. If their case is in New York, we can assist them. The only thing I will say, all of our programs are available statewide, except for our legal information and tech hubs, which are only based in the family courts in the Bronx, Brooklyn, and Queens.
Right. Can a judge suspend visitation without notifying the other parent who's receiving visitation?
Oh, that's a really good question. Um, Generally, no. You have to be served or notified whenever there is a case that is filed in family court against you. The only time that I'm thinking of is if there is an order of protection, a family offense petition that could have been filed, and that would be a temporary suspension of visitation. But every case is different. This is one of those, I'm sorry to say, it depends, but for this unique situation, I would say give our helpline a call and talk through what has been going on in the specific situation. But generally, no, you have to be notified legally about anything that's filed against you in family court.
Okay. So I'm just looking at the chat. Omar Branch, I know he asked us before, do you all personally volunteer to give in-house or Zoom presentations to different providers?
It depends. Feel free to reach out to us, Omar, and we can even message you separately if you want to, or if you want to message us and provide us with your email, we can try to reach out to you that way.
Give me a second.
Sure.
Can I get an attorney when there's a violation of support to represent me as the petitioner?
I can take that one.
Beautiful.
Yeah, so usually in child support cases, the court can assign an attorney to the non-custodial parent or the respondent in a violation case only if they are facing incarceration for not paying the support. Unfortunately, as the petitioner or the custodial parent, the court may not be able to assign an attorney to you. So you would have to either hire a private attorney or find a pro bono attorney or represent yourself.
Great. Give me a second. Can all parties receive free representation? For example, parent one, parent two, and or child, or is it limited in any capacity? I did get a lot of questions whether the NCP can get an attorney or CP can get an attorney. So I'll give it to you guys.
Well, this would depend on the case. So, for example, in a custody case, both parties, the petitioner and the respondent, if they are the parents of the child, do have the right to a court-appointed lawyer, but this would be if they qualify financially. So there isn't necessarily a limitation as to how many parties in a case can have an attorney assigned. If you are a parent to the child, you have the right to a court-appointed lawyer in a custody case if you qualify.
Another question, can you give me some examples that a legal parent has over the child?
I'm sorry, can you read that for me one more time?
Yeah, can you give me some examples that a legal parent has over the child? Like legal decisions,
Legal
essentially?
decisions.
Mm-hmm.
So medical decisions about deciding where a child goes to school. I often say legal custody is not what should my child eat for breakfast, but about the major life decisions in a child's life. So medical, where they should go to school, religion, the major areas, if that helps.
Okay, I'm gonna look at the chat because of Q&A, there's no more Q&A. So I'm gonna look over the chat just to see if
Sure.
there's any. Give me a second. Do you have any intake online if we want to refer a client to a friend, a lawyer for their case?
To find, yep, I see that one. So we don't necessarily have an intake online, but our helpline does have email and live chat as well. So if someone wants to speak with our team about their specific case, they can always email us. And if calling isn't the best option, they can always submit their questions that way or set up a time through email or live chat for one of our helpline program associates to reach back out and potentially set up an attorney or a consultation rather that way.
Another question, I heard no mention of mediated agreements. Do you recommend them?
It's a good question. Depends on the case. Again, I hate to say it depends. Every case is different. Mediation, however, can be an amazing option for parents and caregivers in certain circumstances. So if it's something that you're exploring or you're considering, I would say it's almost always worth exploring and talking with a mediator and asking the court if they could refer you to mediation and seeing if that's a valid option. But it depends on the specific case on whether it would work or not work.
If you are a custodian, say an aunt, are you entitled to a court-appointed attorney?
I don't believe so. Avani, do you know this one?
Yeah, generally in a custody or visitation case, the legal parents have the right to a court-appointed attorney. So it's possible that an aunt or another custodial caretaker may not qualify for a court-appointed lawyer.
Okay. Is support granted to non-custodial parent? Oh wait, is support granted to a non-custodial parent if visitation is 50/59?
Granted. I love this question. When custody and visitation is truly 50/50, so 1 week with parent one, 1 week with parent two, child support is generally calculated based on who the higher earner is, will be the non-custodial parent, and they will be responsible for paying child support to the lower earner. So they will be considered the custodial parent. However, not always, and I've seen where parents have very close incomes and joint physical custody. So 1 week here, 1 week there, child support may not be granted. But again, it depends on the situation. So give us a call for any specific situations. Um, Before we get to our final questions, we'll stay on for just a few more minutes. And I love all of the questions coming in. Keep them coming. I just want to provide our resources one more time and a reminder of how you can get in touch with us, whether you have follow-up questions from today's presentation, or if you need some support or assistance with your family court case, or if you just want to learn more about what we do. Again, you can reach out to our helpline by phone, live chat, or email. And the number again for our helpline is 212-343-1122, and our website is familylegalcare.org. And you can also follow us on social media to see what other webinars and social media lives or other events and resources that we have coming up. All right. And do we have any other questions, Sandy?
Yeah, can a custodial parent take their children to another state or country without the other parent's permission?
Great question. We have a webinar tailored specifically to this, and it's called Relocating with Your Child. It depends on the situation. If you don't have the other parent's permission, we generally say that you need either the court's permission or the other parent's permission or both. So it depends on the circumstances, but generally you would need permission from either a court or from the other parent or both.
Are we doing any more questions or?
We can keep going. I did see, are we able to get a copy of the slides? Yes, if you fill out the survey, we are going to send a copy of the slides with the, once you filled out the survey for us.
Give me a second.
Sure, and thank you, Sandy, for putting that in.
What can you tell our participants do to if the judge provides visitation to the father, but the mother always finds a reason to avoid the father's visits?
What can we tell our participants? Sorry, I'm rereading it. And
Mm.
Ebony, feel free to jump in as well. This isn't, it depends on the situation. Generally documenting and bringing it up with the jurist, you can file a violation petition or an enforcement petition to try to enforce a court order, but it depends on if there's a court order in the first place. If there's not a court order, it sounds like there is, but if there's not a court order, you can always file a petition to establish one. And if there already is one, you can file an enforcement petition or a violation petition to try to enforce the court order or see and let the court know, and the court meaning the jurist, let them know that the other parent is not following that court order.
Another question, can a parent file an order of protection against another parent based on alleged abuse without proof? If the parenting is arrested based upon the alleged report, would that now become a criminal offense?
Sorry, can you read that one more time?
Yeah, of course. Can you hear me?
Yes, no,
Okay.
it just, I want to make sure that I catch everything.
It's like an order of protection inquiry. So can a parent file an order of protection against another parent based on alleged abuse without any proof? And then the other one, if the parent is arrested based on the alleged report, would that now become a criminal offense?
I see. So I can't speak on the criminal offense. That's not our area of expertise, and I would refer you to, I'll go back to the slide on domestic violence and where to get help. But anyone can file as long as they meet the criteria that Ebony had explained for filing for family offense petitions in family court. But they need to prove why they're filing, and they have to prove their case. And that's true for anything that you file in family court. So if you're filing, let's say I file for custody over Ebony's child, I have to prove that there's a really good reason, those extraordinary circumstances, right, of why I need custody and that it's in the child's best interest. So I would need to prove my case. And the same thing with family offense petition, they would need to prove why they're filing and provide that evidence to the jurist, and it will ultimately be up to the jurist to make that determination and that decision.
Next question, what is the specific starting age that a child can determine what parent they would rather be with? And what are determining factors in granting their wish?
It's the best interest of the child factor and standard that we went over. So those factors like continuity and stability and primary caretaker and any other relevant factor, it's those factors that we went over with custody and visitation. It's called the best interest of the child legal standard. There's no specific age that a child can make a determination. Generally, we say around 14, but it can be older, it can be younger, no specific age. I think we'll just take a couple more questions. But again, if you have specific questions on your case, please feel free to reach out to us at our helpline or go to our website. We've got a ton of amazing resources there that may be able to help you with your specific case. All right, just a couple more questions, Sandy.
This is from Edward. Who determines when your wages will be garnished?
It's usually up to the support magistrate. It's usually determined based on when you are paid. So when your paycheck comes in is how I've seen it.
If I don't have a lawyer and the court didn't help with one, would you help to find a lawyer?
We may be able to provide you with some resources or referrals to, depending on your case, and talk through some information that might be able to assist you. But we may be able to provide you with some additional referrals.
This is from Elise. I think it's a bit more specific, but I'm filling for a custody of a 13-year-old. I have a 20-year-old special needs son. Should I file custody or guardianship since he is now an adult?
So this one, unfortunately, this is legal advice, so I can't answer it, but I would say, Elsie, reach out to us at our helpline to see if you are eligible to sit down with one of our lawyers, or if one of our program associates could provide you with more specific legal information about your case and about what would be best for your situation with legal information.
This is from Edward. What is the legal definition of willful not payment of child support?
Legal definition, it's deliberate non-payment. I would have to go back to the statute itself to look up the specific. I don't want to say the wrong legal definition, but generally it's a deliberate non-payment that you have the ability to pay and that you are deliberately not paying when they're looking at a willfulness proceeding.
Just looking to see if there's any other questions.
That may be a good time to wrap up because I know that we are over time. But thank you all so much for joining us today. And again, if you have any specific questions about your case or a case for your client or litigant that comes through your door, please feel free to reach out to us and call our helpline, visit our website, and thank you so much for joining us today.
Thank you, everyone, for being here today and for all of your great questions.